Good morning. Good morning, colleagues. It's nice to see everyone back on the Hill, energized and ready to continue our important work reviewing Bill S5 clause by clause. Tout simplement
For the benefit of interpreters, I would like to remind members of the committee, at least those who are listening to me right now, that when you speak, please don't get too close to the microphone. It can hurt their ears. When we get too close to the microphone, it's problematic for the interpreters. So please maintain a reasonable distance from the microphone. If I understood correctly, now correct me if I'm wrong, Mr. Clerk, with us today, we have Mr. Moffat with us. He will be guiding us in our work. We also have Ms. Farquharson. Inaudible, there is the microphone is rubbing on the piece of paper. The interpreter cannot hear the chair. And from the Department of Health, we have Greg Caro, Director General of Safe Environment Directorates. Now, if I'm not wrong, we were at Clause 7 and Amendment PV10. The amendment is considered to have been presented. And before asking Ms. May to speak to us about the amendment, I would like to say that if PV10 is moved, G8 will not be able to be presented due to a line conflict. So, Ms. May, you now have the floor quickly. Thank you, Mr. Chair. It's good to see all of you again.
It is substantially, my amendment, Parti Vert is quite close in content to Government Amendment 8. But I would urge you to carry this one so it shows some willingness to hear from opposition parties that care about this bill. This amendment adds to, when you look at S5 and you look at the current Section 7 and sub 3.1, the sentence ends with referred to in paragraph 2, sub 1, sub A.2. My amendment will expand that to make it clear that in looking at research studies and monitoring activities in support of protecting the right to a healthy environment, the minister shall be mindful of the wording that's found further up in that paragraph, obviously, including the precautionary principle, principles of environmental justice, polluter pays principle, principles for sustainable development, substitution, non-regression, and intergenerational equity. So those principles are generally found above in the same paragraph. I'll stop there, Mr. Chair. If there's any questions, I'd urge the committee members to give this their support.
Thank you. I'm keeping a list of speakers list. Mr. McLean.
I really appreciate the amendment because it actually defines things that are currently undefined here. So I'm going to. I know a lot of what we've talked about later in the bill. The amendments we propose are about defining these so somebody can actually refer to them and see what they mean. So having definitions this early in the actual discussion of the amendments we're making, I think is very constructive. Thank you.
Anyone else? So yes, go ahead.
Thank you very much, Chair. I'd ask the officials, maybe if I could, just if there's any interpretation challenges, as it seemed seems to me moving in a good direction, making sure there's some clarity, some definitions. But if the officials could comment if the application of previously referred to principles in this paragraph, if there would be any challenges with that in terms of enforcement, the regulatory process, that sort of thing.
Who would like to take that?
Sure, I can. I think the thing is that the amendments have been made in under the duties section to very clearly connect the principles to the right, to make the principles part of the right. And so the purpose of this 44 3.1 is to require research, studies, and monitoring in support of that right, which now, by definition, includes the principles. So it's like that's already included, and this proposal would actually disconnect the principles from the right.
I've been informed that the live stream video and audio are not functioning at the moment. Do you have a sense as to how quickly this can be resolved? We don't know. We're working on it. So we're going to pause for a couple of minutes, and then we'll see where we're at that point. So I don't see any other speakers on this amendment, which means we can proceed. Mr. McLean?
I didn't follow the official's analysis of what she means by this, because it seems to me we're clearly defining what we're talking about here. So I'd like to better understand where she feels that this amendment is disconnecting the legislation from what its intent is.
Ms. Farquharson?
Sure. So under Section 2 of the Act, where it identifies the duties of the government, the committee adopted amendments to say under A.2, there's a duty to protect the right of every individual in Canada to a healthy environment as provided under this Act, subject to any reasonable limits. And then adopted an amendment right under that one in the duties section still that says, in relation to that paragraph I just read about protecting the right, the government has a duty to uphold principles such as principles of environmental justice, the principle of non-regression, and the principle of intergenerational equity. So now we come to Section 44, which is about research, studies, and monitoring activities to support the government in protecting that right. And we know now that the right includes those principles. So adding research, studies, and monitoring to protect the right and apply the principles sort of disconnects the principles from the right. Like you could say it's already included in saying that it's protecting the right. I hope that helps.
So the amendment I'm looking at here is about defining these so that they're clearly understood by anybody interpreting the Act going forward. And by clearly defining these, we're disconnecting it somehow, because these aren't previously defined in the legislation, unless I'm mistaken.
Okay, so I thought we were on PV 10.
We are.
So I think PV 10 says Section 44 of the Act is amended, and under Section 44 is subsection 3.1 that says the minister shall conduct research, studies, or monitoring activities to support the government of Canada in protecting the right to a healthy environment, referred to in paragraph 2(1)(a)(2), and then adds and in
My
applying
mistake.
principle
My
7 of
apologies.
paragraph
Sorry, only because I'm now hoping to make sure that we're all on the same page. So we're currently on version 3 of the amendments package, page 40. Green amendment or PV 10 put forward by Madam May. Okay. And okay, just to make sure we're clear.
Any more comments or questions? No? So I guess we can go to a vote. Mr. Clerk?
Mr. Dogood.
Opposed, Mr. Chair.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson. Mr. Weiler.
Opposed.
Mr. Deltel. I'm sorry, could you repeat?
Yes, sure. Oppose.
Mr. Kirk.
Opposed.
Mr. McLean.
In favor.
Mr. Lake.
Opposed.
Madame Posey.
En faveur.
Ms. Collins.
In favor.
And Ms. Thompson. Ms. Thompson?
My apologies, opposed.
Yeas pour 3, nays contre 8, 8.
Okay, donc l'amendement est défait.
The amendment is defeated. So that brings us to G8. Is that correct? Who would like to present G8? Mr. Weiler.
Understanding is that given that they substantially are the same, that given that the PV10 was rejected, that by the same token, G8 wouldn't be movable.
So you don't want to move it? Okay. So
Mr. Chair?
yes.
Just as a point, I think it is movable, but it may be unwinnable. But I do thank Mr. Weiler for trying it.
Okay. Thank you. Shall clause 7 carry? Mr. Clerk?
So, Mr. Dogood.
Support.
Mr. Longfield. Ms. Taylor-Roy.
Support.
Ms. Thompson.
Support.
Mr. Weiler.
In favor.
Mr. Deltel.
En accord.
Mr. Kirk. Mr. McLean.
In favor.
Mr. Lake.
Oui.
Madame Posey.
Pour.
Ms. Collins.
In favor.
Yeas pour 11, 11.
Okay, so clause 7 carries. Shall clause 8 carry? Does anyone want to speak? Yeah, shall clause 8 carry? There's no amendment, sorry. So we'll go to the vote. On division? That's good? On division? Okay, it carries on division. Clause 9, we have CPC 3. Who would like to present that amendment? Mr. Coury?
Sorry, Chair, just getting.
No, take your time, and up to a point, of course.
So point of order, Mr. Chair, because of I'm the one that sent the amendments to the clerk. So this amendment was written by Mr. McLean. Is Mr. McLean able to move it, or am I the one that has to move it? Okay.
I'll move the motion. So withdrawal of K2, lines 10 and line 11, hydraulic fracturing and tailings ponds. These are additions to the Act that are currently covered under provincial legislation as far as the monitoring of environmental activity that's associated with one specific industry. And as far as tailings ponds go, one specific province, much of which have been ameliorated over the last decade. So I think involving the federal government in an overlapping jurisdictional regulation here is adding more bureaucracy into the environmental oversight of one industry in particular. And I think it's I think it's something that might be opposed from provincial governments across the country if it's put forward this way. And I suggest that we withdraw it at this point in time in order to make sure that it is something that's clearly done and regulated at the provincial level where it is done very effectively currently.
Anyone have anything to add? Ms. Collins?
Well, I would definitely disagree that tailing ponds are predominantly remediated and that these kind of issues are being dealt with effectively. And yeah, it definitely doesn't only have to do with one province. There are tailing ponds in mines across the country. And this is an ongoing issue. I think it would be a tragedy to delete these two lines. So I hope we don't.
Anyone else? Mr. Longfield?
Thanks. I'm just rebooting my computer to see my notes, but as I recall, this falls tailings ponds are not excluded from the existing legislation, so it's already covered in the legislation. So I'd support taking them out just as a matter of redundancy.
Weiler?
Yeah, I would agree with Mr. Longfield here. Clearly, hydraulic fracturing and other activities that cause tailing ponds are activities that are covered under K1, which are activities that may cause or they may contribute to pollution. So by removing this, it is a redundancy that we're removing, but certainly we should be concerned about the potential for those activities to cause pollution to the environment and to human health.
Ms. Taylor-Roy?
Yes, I agree. I'm quite concerned about these activities as well, but as Mr. McLean has said, it's in provincial legislation, but I don't think that not specifying them here actually prohibits us from the government from looking into that, because if they are causing pollution, they will be included in there. So, I mean, I understand what you're saying about the provincial federal jurisdiction, but I don't agree that the federal government shouldn't have any role, but I don't think it's necessary to spell them out here.
Yes, Ms. Collins.
I guess I'm a bit confused about if this is something that the legislation is covering, why people would be opposed to specifically naming an instance of environmental pollution that we need to address. So it's surprising to hear my colleagues across the way in support of removing something where we should be addressing this issue and we should be addressing it and naming it.
Anyone else? Ms. Taylor-Roy?
Yeah, just to respond to that, I think that these are the issues we're talking about right now, these two specific ones, but given that this legislation hasn't been updated for decades and that this is likely to stand for a while, I think trying to name things, all these things in the actual legislation is problematic because these things will change over time and there's going to be other things that come up. And if we list things and it's not exhaustive, it's kind of like, well, it's issues that are important right now, but that may change over time. Perhaps these won't be an issue down the road. So I just don't know that we have to put details like this into this legislation when we have the regulations and we have the framework coming up as well.
Ms. Collins?
I love my colleagues' optimism that we're going to address these issues quickly, and the government has repeatedly said that they are going to be bringing back this legislation for further updates. So I hope they are genuine in that those statements. And if that is the case, putting in explicit mention of environmental pollution, an instance of environmental pollution, and in particular tailings ponds, that we do need to address now, shouldn't be a problem, given that the government has promised to bring this legislation back to keep updating it.
Okay. I don't see any other requests to comment. Shall CPC 3 carry?
Mr. Duguid.
We.
Mr. Longfield. Ms. Taylor-Roy.
We.
Ms. Thompson.
Approve.
I'm sorry, was that in favor?
In favor.
Thank you. Mr. Weiler.
Yes.
Mr. Deltel.
Pour.
Mr. Kirk.
In favor.
Mr. McLean.
In favor.
Mr. Lake.
Yes.
Madame Posey.
Ooh.
Ms. Collins.
Opposed.
yeas pour 10, 10, nays contre 1, 1.
CPC 3 is carried. Shall clause 9 carry as amended? On division? Okay. Which brings us to clause 10 and PV 11, which is deemed already moved. And I'll just mention that if PV 11 is adopted, NDP 12 and NDP 13 cannot be moved because of a line conflict. Ms. May.
Thank you, Chair. And I know that given the strictures of the motion that compels me to be here if I wish to make amendments, which would otherwise be my right at report stage, I have to be brief. This is particularly challenging with this amendment because it is 5 pages of content that is intended to replace what we find now under S5 running from, basically Section 10 and what would be in the new version of SEPA, Sections 56(1) right through to the beginning of the next subsection. The goal here, rather than try to walk you through the amendment, for which I obviously won't have time, I'll at least explain the rationale. The Canadian Environment Protection Act has had a discretionary approach and to the creation of pollution prevention plans. There's basically 2 strategies under the Act. You can have a pollution prevention plan or you can have a pollution abatement approach. If you're going to eliminate toxic substances, particularly those that are carcinogenic, that are mutagenic, that are seriously a threat to human health, bearing in mind that this Act is both environment and human health, and that both ministers play a role, Minister of Environment, Minister of Health, even though we're before the Environment Committee. These are seriously dangerous chemicals for human health, and yet of the 19 substances that were listed as eligible for this kind of pollution prevention plan, so far in the experience we've had since 2000, only 25 substances out of 150 had a pollution prevention plan created.
So this amendment, then, it requires, could you just explain what the amendment?
Yeah, the purpose of the amendment is to ensure that those chemicals that are significantly a threat to human health have a mandatory requirement on the manufacturer to move away from them. There are sections here that allow us to consider that there's an economic problem with moving to elimination, but in brief, and it is hard to do this in brief, this would make pollution prevention plans mandatory for all Schedule I toxic substances. It's about eliminating the creation and use of toxic substances.
Okay, well, that was very clear and succinct.
Thank you.
Go ahead, Mr. Duguid.
Thank you, Mr. Chair. I just wonder if we could hear from officials on this. I know the folks from CELA had brought this up a number of times.
Who would like to address this?
Wouldn't mind hearing their perspective.
Mr. Moffat? You're on mute, Mr. Moffat.
Is that better? Can you hear me now? Sorry.
Yes, we can, yes.
Okay, my apologies. I don't think that we have any objections to the stated goal of promoting pollution prevention in that the Act itself already requires ministers to give priority to pollution prevention when risk managing substances. The challenge with this amendment is that it would require the government to require pollution prevention plans with respect to every listed substance. In fact, pollution prevention planning is only one way to promote pollution prevention. It's a bit unfortunate that the term pollution prevention planning has become confused with the overall concept of pollution prevention. When we assess a substance as toxic and needing risk management, SEPA gives us access to a wide range of risk management instruments, including the authority to require plans, but it also, of course, authorizes us to regulate, including to prohibit the use of a substance, which is the most effective and powerful way to achieve pollution prevention. It ensures that the substance is not used and therefore never enters the environment. So by requiring the ministers to use this one tool for every substance, it in fact would be an unnecessary imposition when in fact other more stringent and more immediately effective measures can and have been used to achieve the overarching goal of pollution prevention.
Thank you. Would anyone else?
May I respond?
Very, very, very briefly, please.
I'm sure inadvertently Mr. Moffat has mischaracterized this amendment as requiring a pollution prevention plan for every substance. As I mentioned, if you look to subsection 13 at page 47 of your amendment package, the applicant may have the opportunity to convince the minister that socioeconomic benefits of an activity outweigh the risk and the analysis of alternatives. There are ways to continue to deal with each substance. It isn't a flat prohibition, but it does give the minister tools that currently are not found in this act, and the duty to regulate where substances are extremely dangerous.
Thank you. Ms. Collins?
I was going to say the same thing. I read through the amendment and I saw a clear path to the minister not doing this if it was shown, as Ms. May has just explained.
Excuse me, anyone else? Okay, we can go to the vote on the amendment.
Mr. Duguid.
Opposed.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Oppose.
Mr. Weiler.
Opposed.
Monsieur Deltel.
Oppose.
Mr. Kirk.
Opposed.
Mr. McLean.
Opposed.
Mr. Lake.
Opposed.
Madame Posey.
Pour.
Ms. Collins.
In favor.
Yeas pour 2-2, nays contre 9-9.
Alors, l'amendement est défait. Et...
The amendment is defeated, which brings us to NDP 12.
Since it
Okay,
would...
alors, l'amendement ne se...
The amendment will not be presented. Mr. Chair, yes, Ms. Posey. Given that that amendment is not being presented, I have one that the clerk has that I'd like to table now on the fly. And what it says, the interpreter doesn't have the text. It's that in Article 10 at line 34 of page 7 of the Act, it says that if it believes, based on evidence, independent evidence, information provided by the requester, and that this is reasonable. What I mean here is that currently the industry justifies itself, and we know what has happened. I can give the example of Louis Robert in Quebec. The industry has too much influence on decision making. So if we have independent studies in addition to this, then there could be some balance. Well, what we're saying is that before we move to your amendment, we need to deal with amendment NDP 13. Ms. Collins.
Mr. Chair, and I'm very interested in Madame Posey's amendment as well. But I chose not to move NDP 12 because it would conflict with NDP 13. And so the amendment itself really is to incorporate the principle of safer substitution into this Act. And if my colleagues will, if they haven't read through it thoroughly, definitely look at the section 1.1 that talks about more sustainable alternatives to the substance, using safer alternatives. I hope that I'll find the committee's support for this.
Sorry, I forgot to mention that Yeah, okay, so you can move it, yeah. Who would like to speak to it? Well, Ms. Collins just presented it. Would anyone else like to speak to it? Madame Posey?
C'est juste.
I don't understand one thing. The part that's in parentheses is very different in English compared to the French. One moment, please.
C'est dans le NDP 13.
This is in NDP 13:10. To answer Ms. Posey's question regarding the difference between English and French, is that what you're saying? Yes. Where? Under the fourth heading. Can you say what you said last time? Where's the difference? Where you see the 4 between brackets under substitutions, lines 28 to 35, then there's a 3, then there's point 4. I just think there's a chunk missing when you see how long the English is compared to the French. Translation omitted 3 lines. I'm not a legal translator. I'm not involved in this, but you know, just reading it at a glance, you can see that there's a big difference between English and French.
That period to have the extension.
C'est assez évident.
Yes, indeed, it is quite obvious that there's a difference.
Est-ce qu'il y a moyen de...
Is this something we can send back to them? Inaudible to the interpreter.
Alors, je pense que ça vaut la peine, mais on peut vérifier.
I think we can do this. Can we check in the meantime? The response is inaudible to the interpreter. What we're suggesting here is that there are already 2 amendments that have been set aside for the end. Perhaps we can add NDP 13 to this as well. Ms. Posey, correct me if I'm wrong, but you're saying that your amendment, the one that you would like to present, depends on the decision we make regarding NDP 13, correct? So can we set NDP 13 aside? And Ms. Posey, your amendment will also be set aside for now as well. We'll move this to the end, and this will give us an opportunity to verify if there was just a simple mistake in the translation.
Just to clarify, if we're setting that aside, would we not set the whole section aside as we did?
Yeah. So basically, clause 10 is, I guess, stood, or if I don't know if that's the proper term, but okay. So, alors on peut.
Okay, so we can move on to clause 11. Yes, we can continue. One moment, please. We will take a short break. And that's why this is catching our eye. But in this case, the French is more succinct because the idea of granting an extension is wrapped up in the term nouveau délai in the French version. So it replaces the whole notion of the extension being granted. I understand. But then why is it specified in English that are included in the French? But then the French word is found in the English version. Well, I can't answer this, but it's been like this for years. This wording has been there for years and no one has raised the issue. Can I remind you the discussion about the precautionary principle? I would rather that we wait and see the answer. I move that we wait to hear because Mr. Deltel's point is relevant. You know, we found a precocious principle and it had been there for 20 years and we corrected it. Yes, indeed, but it's up to the committee to decide if it would like to put this decision to a later time. Can we vote on that? Can we vote on delaying the decision on this? Do we have unanimous consent to delay this?
Stand for now. Anyway, it's very interesting. Pardon? Oui, on s'en va à la...
Yes, so we're moving to clause 11. And we're speaking to amendment PV12 proposed by Madame May. Yes, one more thing, Mr. Chair. The amendments that have been proposed by Ms. May are so important, so detailed, I think she should have the time to present them correctly. I'm doing what I can, given the rules that have been imposed on us. But Ms. May, I have to say, does an excellent job at summarizing her ideas. I encourage all members to follow her example. So, Ms. May, go ahead and present your amendment.
Thank you, Mr. Chair. And again, this is a detailed amendment. Again, I should have credited the expert work of the lawyers at the Canadian Environmental Law Association, particular Senior Counsel Joseph Castrilli, for assistance in the drafting of these. And of course, by the way, we all know how much the legislative clerks help us. You can imagine when I ask them for amendments that are 4 and 5 pages long and they deliver them on time, and I'm very grateful. This one is 4.5 pages to replace a single paragraph. So what you have in S5 is subparagraph 60 sub 1, which has the requirement to submit certain plans. What amendment PV 12 does is to ensure that we actually have content for what the components of a pollution prevention plan should consider. Even though my previous amendment making such work mandatory has been defeated, this would still be very helpful in setting out in those cases when the minister does require a pollution prevention plan, knowing what the content of that plan should be. Thank you, Mr. Chair.
Thank you. Who would like to speak to this? If any, Ms. Collins?
I just want to thank Ms. May for putting this forward. And the principle of moving from prevention abatement to pollution prevention is an important one, and I thank her for putting it forward.
Anyone else? Shall we go to the vote?
Mr. Dogood,
Opposed, Mr. Chair.
Mr. Longfield,
Oppose.
Ms. Taylor-Roy,
Opposed.
Ms. Thompson,
Oppose.
Mr. Weiler,
Contre.
Monsieur Deltel,
Contre.
Mr. Kirk,
I'm opposed.
Mr. McLean,
Opposed.
Mr. Lake,
Opposed.
Madame Posey,
Pour.
Ms. Collins.
In favor.
Yeas pour 2, nays contre 9.
Donc, l'amendement est rejeté.
The amendment is defeated. And we must now vote on Clause 11 as it is. Mr. Clerk.
Mr. Dogood,
Carried.
Mr. Longfield,
In favor.
Ms. Taylor-Roy,
In favor.
Ms. Thompson,
In favor.
Mr. Weiler,
In favor.
Monsieur Deltel,
En accord.
Mr. Kirk,
Support.
Mr. McLean,
En faveur.
Mr. Lake, Madame Posey,
Oui.
Ms. Collins.
In favor.
Yeas pour 11.
Donc, c'est unanime, l'article.
So it is unanimous. Clause 11 is carried. This brings us to Clause 12 and Amendment PV 13 presented by Ms. May.
I guess for purposes of people watching these proceedings, it needs to be said that my amendment here replaces one line, but that one line is highly significant. We worked hard, I wasn't in the Green Party then, in the environmental movement in a first overhaul of one of the many overhauls of the Canadian Environmental Protection Act to include the concept of virtual elimination, so that substances that were extremely toxic on the list of toxic substances could be scheduled for virtual elimination. That was a hard-won achievement. And in one fell swoop, Section 12 of S5, that virtual elimination process and the list is repealed. I don't think this is justified. I think it weakens the Act, as I think overall the Liberal efforts on S5 weaken what was put in place in 1988 under Brian Mulroney. But just to say, my amendment restores the virtual elimination list from the acts of repeal and further clarifies how it can be used in future. Thank you, Mr. Chair.
Thank you, Ms. May. Would anyone else, Mr. McLean?
If I could have further explanation from the member on how this weakens, we've already gone through this intergenerational equity, non-regression, et cetera, and how these terms may weaken what's already in there. I thought everything we're doing with here was actually strengthening our environmental protection mechanisms. So if I could have a clarification from the member on that and subsequently from the officials involved, I would appreciate it.
Ms. May, briefly, please.
Yes, the fundamental way in which S5 weakens environmental protection is in the elimination of a single schedule at the end of the Act as a list of toxic substances. Most of my amendments for the rest of my time in this committee will be to try to defend the schedule of toxic substances as a single list. This is the largest weakening because it undermines the constitutional foundations of the Act as determined by the Supreme Court of Canada in the Hydro-Quebec case. In this case, virtual elimination allows for substances to be reduced to such a level that there's the cessation of intentional production, use, release, export, distribution, and also to focus on how these products may be created as byproducts. I agree if you ban them altogether, you don't need a virtual elimination list, but the virtual elimination list has been a way in the past of ensuring that toxic chemicals are scheduled for their virtual elimination and are steadily reduced over time. If that helps.
Yes, I guess I don't know who which official you would like Mr. McLean to address this, Mr. Moffat or Ms. Farquharson.
whoever chooses.
Who would like to? Who would like to jump in?
Perhaps I can start. The government did adopt the concept of virtual elimination both in the toxic substances management policy and in the statute when it was amended in 1999. Since then, however, the virtual elimination regime in the Act has proven to be unworkable and has had almost no impact on decision-making in the federal government or on actual prevention of risks. So the government in S5 is proposing to replace that regime for two reasons. One, as I said, it has proven to be not workable for a variety of reasons. But second, the government also intends to expand the underlying obligation. So the underlying obligation of virtual elimination is to essentially say that there are a number of substances that are problematic. Those are toxic substances. Some are particularly of concern and need to have particularly stringent risk management actions taken to achieve virtual elimination. And those substances, at the time that virtual elimination concept was developed, were confined, that subset was confined to substances that are persistent, that last a long time, and that bioaccumulate in living organisms. Of course, in the last 20 to 30 years, we've identified a number of other sets of substances that are equally of concern. And so we've already discussed in this committee the concept of mutagenicity, carcinogenicity, and so on. And so the S5 proposes to replace this narrow concept of virtual elimination of persistent bioaccumulative substances with a much broader authority to identify substances of highest concern, to give some guidance in the statute, and then require the ministers to develop by means of regulation the broad criteria to determine what substances will be on that list and thereby require more stringent risk management than other toxic substances. So the goal is actually not to weaken. The goal is to broaden this category and to also to avoid some of the unintended challenges that arose with respect to the implementation of the original virtual elimination, and to enable and to give the government broad authority to take very stringent action on that broad new subset of substances.
Thank you. Ms. Taylor-Roy, followed by Mr. Weiler.
Thank you. I think the explanation answered my question. I think I was concerned about weakening it, but it appears that we're actually broadening it and strengthening it. So I'm fine.
Thank you, Mr. Chair. And separate but related to that, Mr. Moffat mentioned that the virtual elimination system was unworkable due to a number of factors. And I was hoping, for the sake of our committee, he could expand on what those factors are.
I can try to give you a brief explanation. In fact, previous iterations of this committee have reviewed this issue a number of times and have come to the conclusion that in fact the regime is unworkable, including in its most recent review of SEPA and in a review of a private member's bill about 10 years ago. Essentially, the notion of virtual elimination of trying to eliminate the presence of the substance is not the concern. The concern is that when you introduce a concept like that, you have to define it, and you also have to require specific actions. So in the statute at the moment, you have to develop a particular kind of regulation over and above the Section 93 obligation to regulate. So we have this obligation to develop two regulations when, in fact, if you're prohibiting the substance, there's no point in adding a second regulation. we also have defined virtual elimination in a way that requires, that refers to quantification of the substance, so the ability to measure the substance. And in some cases, we can monitor emissions of a substance and identify what the lowest level of quantification is. But in a lot of cases, substances that we're worried about are used diffusely. In other words, they might be part of a treatment of millions of shirts, and come off in the walk, and so we can't actually quantify the emissions from the use of the substance. So the way in which we defined virtual elimination was something that we meant that we actually could not comply with the law and could not develop the regulation that was required by the law. So rather than adding substances that were persistent and bioaccumulative to the schedule, we simply added them to the regular schedule of toxic substances and then took significant action such as prohibitions. So we achieved the goal, but we actually were not able to comply with the specific provisions in SEPA 1999, which is why there are so few substances on this list.
Thank you. Mr. Couric.
Thank you very much. We certainly heard in testimony that one of the challenges that that industry faces, and also that was highlighted by environmental groups, is the administrative burden and effective regulations, not just having an additional list with the ability for things to be added and some of the challenges as science evolves and things change. So just wondering, with regard to this amendment, if the officials could just comment, it talks about there being an additional list created, possible administrative burden associated with that. If that would, it's been referenced that would be taking away from other parts of the Act that attempt to deliver on some of the intent here. So I'm not sure if Mr. Moffat or one of your colleagues would be able to comment on that.
Excuse me. Sorry, that's a question for Mr. Moffat? Yeah.
Yes. Yeah.
Well, again, I can start. I'm getting a lot of, that's better. So I can comment on the actual amendment in Clause 12, which is to eliminate the whole virtual elimination regime, which did require addition of or the creation of a second list. However, as I just explained, we are in S5. We are also proposing kind of a second list, if you will, a list of substances that, because of certain characteristics to be defined in regulation, merit or need to be identified, put on a list, and then subjected to very stringent risk management actions. At the officials level, we have advised that we're not concerned about kind of the administrative burden either on government or on industry associated with that list. In fact, what we want to do is define very clearly for government decision makers and for industry precisely what those criteria would be that would determine whether a substance goes on that list. That will provide certainty to industry. And then if a substance is on that list, then again, there's also certainty about the kind of risk management action that one can expect from if you're in the business of using or creating that substance. So it's our view that, in fact, we'll be providing more certainty to industry about a broader range of substances than is the case at the moment.
Okay, Mr. McLean?
Mr. Moffat, I need something addressed here that Ms. May raised. The amendments currently in front of us will change the constitutional foundation of the Act. Now, you mentioned something about Section 93 and its duty to regulate. Is that what we're talking about here? Or does this change the constitutional foundation? If you could give us a quick briefing, 2 minutes or less, please, about the court case that Ms. May referred to, the Quebec Hydro case, and how this will impact a constitutional foundation of this act, please.
Well, I need to clarify, I'm not here as a lawyer, nor are we providing legal advice to the committee, but the Quebec Hydro cases, of course, has been public for decades and has been fairly well reviewed and understood. And in its essence, the Supreme Court, well, first of all, there were a number of different decisions that led to the court, on the part of different members of the court, that led to the court deciding that the particular use of a regulation under Part 5 of the Act was constitutional. Without getting into all of the details, I think the general thrust of the decisions that supported Part 5 were that the Act establishes a process that enables the government, or that requires the government, to identify particularly significant risks, and through, of course, the kind of starting with monitoring, information gathering, and then a formal risk assessment, and then a conclusion that goes to the governor and council that leads to the list of substance, and then the development of a regulation to address that risk. So there is a gradual kind of a process of identifying really significant risks, and which then justifies the federal government stepping in and taking action to prevent that risk on the part of the Canadian environment as a whole and the health of Canadians as a whole. Again, it's our view that we're not changing the nature of that process. In fact, we are attempting to refine that process by adding additional authority to identify specifically which substances are of particular concern and merit a particular track of risk management.
Thank you. Thank you. I've got Ms. Collins. No, did I miss anybody? No, Ms. Collins, yeah. And then Ms. May briefly. No, very briefly.
So I appreciate Mr. Moffat's comments, particularly about the issues around quantification. But my understanding of this amendment is that it actually kind of fixes that. It reintroduces the concept of virtual elimination, but without some of the problems in the previous act. And I guess I did have a question for Mr. Moffat. Particularly, he had mentioned, moving from this regime to the regime of, what is highest risk, and in particular mentioned, CMR, the carcinogenic, mutagenic, and what's risk to reproduction. And so I just wanted to hear some clarity around, how those concepts are incorporated into the new regime.
So, in the regime established under S5, the bill would require the ministers to take particular actions to risk manage substances that meet certain criteria. The Act also provides authority to articulate those criteria and put them in regulation, and the Act provides direction, or the bill rather provides direction about kind of at a minimum what those criteria need to include, and it explicitly references the concepts of carcinogenicity, mutagenicity, and risks to reproductive processes, and so in addition to the initial approach, which, as I described, focused exclusively on persistence and bioaccumulation, we would now be obliged to develop a regulation that also develops criteria associated with those three other concepts, and then would provide authority to identify additional concepts or criteria, rather, that may be identified, may emerge from domestic or international science over time as being relevant to define, again, a subset of substances that are of particular concern and that merit particularly significant risk management actions.
Thank you. Thank you. Ms. May, very briefly. Sorry, are you through? You have
Quick follow-up
more?
question for Mr. Moffat, just for clarification. So my understanding is that like the regime of highest risk and using CMR principles is incorporated into the rest of the bill. I'm just confused about why adding virtual elimination back in would in any way threaten that, because this isn't taking out any of the new references to carcinogenic, mutagenic, and risk to reproductive function. Yeah, I'm still leaning towards supporting this because it seems like an important principle that was eliminated in S5, that this amendment has addressed some of the concerns around quantification of release, and it seems like it would be good to have kind of both of these principles here.
Mr. Moffat?
I want to be careful not to get into a situation where I'm debating the merits of amendments with members of the committee, and I want to respect your role in decision making. I think the concern that as officials we might have with this amendment is that it's not that the bill attempts to kind of create a new list of substances of concern. If we in addition retain the concept of virtual elimination and retain a virtual elimination list, then we actually have three lists, and the purpose of the virtual elimination list and why it is distinct from this new list is not clear and could add confusion to the intended functioning of the Act. So it's not a concern about the notion of persistence of bioaccumulation as being indicators of risk, nor is it a concern about the need for the statute to signal the need for more stringent action for some substances. But I think we would be concerned about a proliferation of lists.
Thank you. Ms. May, very, very, very briefly, please.
Fascinating. He's concerned about the proliferation of lists by creating two lists instead of one. But if I can go back to the virtual elimination point, this amendment, PV 13, everything Mr. Moffat said about it would be true if all we were doing was repealing the line found at line 33 on page 8. But we are replacing the language, the very concepts that Mr. Moffat just explained to us as why it was problematic, that you couldn't get out and quantify it in the environment. I go back to the original Canadian Environmental Protection Act as amended in 1999, so committee members will have fresh in their mind the language, ultimate reduction of the quantity or concentration of the substance in the release below the level of quantification. That's the language that was problematic. My amendment replaces that language to focus on virtual elimination by removing the product from commerce. It's straightforward. It does not include anything of the issues that have bedeviled since 1999. I don't take away from anything Mr. Moffat said, that since 1999 it's been hard to quantify in the environment to move towards virtual elimination, which is why my amendment not only restores the Virtual Elimination Act to the Canadian Environmental Protection Act, but refines it to eliminate the problems, as Ms. Collins so helpfully pointed out.
Understood. Okay. Ms. Taylor-Roy?
Yes, thank you, Mr. Chair. I'm very sympathetic to what this amendment is trying to do and to the arguments being made, but my issue is that since the entire regime was changed and the bill was overhauled, that going back and trying to put in one area of this virtual elimination and create this list now when there's a new approach being suggested, it seems to me like it doesn't work with what's been done already. And so, while I hear what you're saying, I also feel like the realities or the problems with actually implementing this were considered when they put forward the bill, and they try to address that in a comprehensive way. So now to go back and say, well, we fixed virtual elimination, let's put it back in, I don't see how that works completely. So I understand what you're saying, but I'm really hoping that in the regulations that are going to be very, very important, obviously, in this case, that we're going to see a lot of strengthening in those as well. So
Okay,
I
thank you.
can't support this.
Okay, seeing no other comments, can we proceed to the vote on PV 13?
Mr. Duguid.
Opposed.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed.
Mr. Weiler.
Opposed.
Mr. Deltel.
Contre.
Mr. Couric.
I'm opposed.
Mr. McLean.
Opposed.
Mr. Lake. Madame Posey.
Pour.
Ms. Collins.
In favor.
Yeas pour 2-2, nays contre 9-9.
So the amendment is defeated. Shall clause 12 carry? On division, we're good? Okay. Now, I've been informed that there was a bit of a computer glitch. So on my list here, after I asked if clause 10 would carry, there is no mention of clause 10.1. So I need to ask whether clause 10.1 can carry. There was no proposed amendment to clause 10.1. So can clause 10.1 carry? On division, okay. And the same thing for 11. I should have asked, there should have been mention of 11.1. For some reason, there was a computer glitch, and 11.1 doesn't show. So shall clause 11.1 carry? On division? Okay. And we just carried 12, right? We just carried 12, yeah. So shall clause 13 carry? There's no proposed amendment to clause 13 on division? Okay. Which brings us to clause 14 and amendment G9. Mr. Duguid.
Thank you, Mr. Chair. I propose this motion which seeks to clarify the policy intent in Clause 14 and associated Clause 39. Recent feedback has made it clear, Mr. Chair, that the bill was vague and open to interpretation, as the intent was to include only those substances that were on the revised in-commerce list. And, Mr. Chair, this fixes that. I would so move.
Debate? No? Can we go to the vote?
Mr. Duguid.
In favor.
Mr. Longfield. Ms. Taylor-Roy.
In favor.
Ms. Thompson.
In favor.
Mr. Weiler.
In favor.
Mr. Deltel.
En accord.
Mr. Couric.
In favor.
Mr. McLean.
En accord.
Mr. Lake.
Yes.
Madame Posey.
Oui.
Ms. Collins.
In favor.
Yeas pour 11-11.
Okay, so G9 carries. Shall clause 14 as amended carry? Clause 15, we have G10. Who would like to move that? Yeah, Mr. Duguid.
G10. So, Mr. Chair, I'd like to...
I should mention something before we do I mention this before he speaks to it? Yeah. If G10 is carried, NDP 14 cannot be proposed because of a line conflict. Yeah, okay. So go ahead, Mr. Duguid.
Okay, we're on G10, Mr. Chair?
Yeah.
So again, Mr. Chair, I'm proposing this motion to make a minor revision to the new 67(1)D, although the current version of paragraph 67(1)D already provides broad enough regulatory authority to prescribe such procedures and practices, the government proposes to support the provision with minor revisions to ensure that the conditions, procedures, and practices are described concurrently throughout paragraph D. Minor revision, Mr. Chair.
Ms. Collins?
Yeah, well, this will mean that my amendment won't be able to move. I do support, the addition of the word laboratory practices. I think spelling out some of these is useful, and especially given the testimony that we've heard from a number of experts. So I appreciate it.
Hey. Are we ready to wait, Mr. Kirk and then Mr. McLean?
I think that as reading through this and some of the other references and how broad it was before, I think this is certainly in line with trying to narrow and define some of the aspects and looking at it from an agricultural perspective. For example, I think that this tightens up some language that could otherwise have been misinterpreted, and certainly it's better to have it clear now as opposed to decided by the courts later.
Thank you, Mr. McLean.
Look at how it's going to read on the English paragraph, please. So it's going to testing conditions, test procedures, and laboratory practices to be followed for replacing, reducing, or re-measuring.
So,
just looking for clarification on what the final. So we're replacing line 10. Or pardon me, line 23 on page 10. So line 23, we're testing conditions, test procedures, and laboratory practices to be followed for replacing, reducing, or
Mr. Chair?
yes.
I believe the clerk can confirm, but I believe the intention is that the third is refining. So it would read to be followed for replacing, reducing, or refining the use of vertebrate animals, and that is the sequence that has already been adopted in other amendments that the committee's already discussed. So the concept of replacing, reducing, or refining is just repeated here.
The wording, the English wording, does the English wording of the amendment need to be changed, or is it somehow understood? Or? Okay, thanks. Okay. Yeah.
If Mr. McLean is interested in doing some kind of sub-amendment to take out the word refining, he will note NDP 14 did remove that word, and so he would have my support in that if he was interested.
Are you?
I will leave that to the NDP to modify if they'd like.
Okay, yes.
Given the, I would say, temperature of the room, my guess is it wouldn't pass, so I will leave it be.
Okay, so we're now voting on G10, correct? Yeah. Shall G10 carry?
Mr. Duguid.
In support.
Mr. Longfield.
Favor.
Ms. Taylor-Roy.
In favor.
Ms. Thompson.
In favor.
Mr. Weiler.
In favor.
Mr. Deltel.
Pour.
Mr. Kirk.
In favor.
Mr. McLean.
In favor.
Mr. Lake.
Yes.
Madame Posey.
Pour.
Ms. Collins.
In favor.
Yeas poll 11 ohms.
Okay, so G10 carries, and therefore NDP 14 cannot be moved. We'll now go to G11. Mr. Duguid.
Thank you, Mr. Chair. And the government side proposes to revert to the original text of the bill as introduced vis-a-vis paragraph 67(1)E. If enacted, unamended. The Senate NEV committee amendment also risks undermining the risk-based approach to chemicals management under CEPA and the CMP, Chemicals Management Plan, more broadly. So I would place that amendment on the floor, Mr. Chair.
Debate, Ms. Collins.
Yeah, I understand the government's concerns about changing from highest risk to highest concern. I do think that in addressing this, taking out the specific references to carcinogenic, mutagenic, and toxic to reproduction does a bit of a disservice, especially given the testimony that we had heard earlier about explicitly referencing these pieces. And so I would propose a sub-amendment. So keeping the change to the highest risk, but it would read classification of a substance as a substance that is carcinogenic, mutagenic, toxic to reproduction, or poses the highest risk.
It would help if you have a copy written down that the legislative clerks could.
I can email something. It's very similar to the language of that this is replacing, except for the highest.
Can you email it to
I
the
will,
clerk?
absolutely.
Yeah, we'll just take a moment here. I think you need us to wait before we debate the amendment? No? Okay, go ahead, Mr. Duguid.
Mr. Chair, just in light of the sub-amendment that has been proposed, again, I wonder if there's some reflections from officials on both the amendment and the sub-amendment.
Ms. Farquharson, Mr. Moffat, who would like to reflect on this?
I'm hoping I can ask my colleague, Ms. Farquharson, to explain the way in which the bill, as proposed, already, in fact, includes the concepts of, as I explained earlier, carcinogenic, mutagenic, and toxic to reproduction. Go ahead, Laura.
Sure. So under Section 77(3), where after it's been determined that a substance is toxic, it says there's a part that says mandatory proposal, and it says if the substance is toxic and A, persistent and bioaccumulative, B, a danger to human health, and carcinogenic, mutagenic, toxic to reproduction, or C, otherwise of highest risk, it must be put on Part 1 of Schedule 1. And for both of those, for all three of those, that provision also says as defined in the regulations. So that's where you have the specific mention of CMR substances as being those that should be on Schedule 1 as defined, like CMR as defined by the regulations. So then if you go to Section 67, that's the regulation making power. And it says already you can make regulations about characteristics of a substance. And I want to make sure that I'm right about this, but it includes about carcinogenic, mutagenic, or reproductive, toxic to reproduction. And then so this provision that you're looking at right now is the reg making authority for substances of highest risk. So if that makes sense, CMRs are specifically mentioned where it says that you should put them on Part 1. And then in this reg making authority, there are two subsections, one about defining what CMR means and one about highest risk.
Okay.
And so your argument would be that there is some redundancy in the sub-amendment?
Yes, including CMR redundancy, and then we really need to get highest concern. I mean, for the bill to be coherent, it should say highest risk, not highest concern.
Right.
Yes, Ms. Collins.
Just point of clarification about the amendment that I proposed. It still keeps the the principle of highest risk, so did not change the word concern, or did not revert it to concern, and really just outlines those principles. And you'll notice says or poses the highest risk, similar to how it's mentioned in other parts of the bill. And really what the concern here is, and if people were following the Senate committee hearings, is, the Senate had introduced this language and to explicitly spell out that CMR, so carcinogenic, mutagenic, and toxic to reproduction, are critical elements that need to be reinforced throughout this. We know that in the previous regime, we've heard testimony that virtual elimination wasn't working, needed to be addressed, in part because these principles weren't incorporated and weren't being reinforced throughout. So I do hope that the committee will support including these here as well, and won't water down the amendments that the Senate put forward on this. Thanks.
Okay, so we're debating Ms. Collins' amendment. Any more? Sorry, sub-amendment to amendment to the amendment. That would make it a sub-amendment. So yes, we're debating that. Anyone else? Would anyone else like to add something? No. So we can vote on the sub-amendment.
Mr. Duguid.
Contre.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Oppose.
Mr. Weiler.
Opposed.
Mr. Dedtel.
Contre.
Mr. Kirk.
I'm opposed.
Mr. McLean.
Opposed.
Mr. Lake.
Opposed.
Madame Posey.
Pour.
Ms. Collins.
In favor.
Yeas pour, 2-2, nays contre, 9-9.
Okay, so the sub-amendment is defeated, and we go back to Amendment G11. Was there any more to say about that? Doesn't look like it. So we can vote on G11 now.
Mr. Duguid.
Je vote pour.
Mr. Longfield.
In favor.
Ms. Taylor-Roy.
In favor.
Ms. Thompson.
In favor.
Mr. Weiler.
In favor.
Mr. Deltel.
En accord.
Mr. Kirk.
I'm in support.
Mr. McLean.
En faveur.
Mr. Lake. Madame Posey.
Non.
Ms. Collins.
Opposed.
Yeas pour, 9-9, nays contre, 2-2.
Alors, l'amendement G11 est adopté.
The G11 amendment is adopted. Now I'll ask you if you want to adopt Clause 15.
Est-ce que vous voulez, est-ce qu'on doit adopter?
Should we adopt Clause 16 with division, on division?
Just clarifying, because there's clause 16 and then it goes on to 16.1, et cetera, et cetera. So I think there's a proposed amendments.
There's proposed amendments are 16.1.
Okay.
Yeah. So shall clause 16 carry on division?
On division.
Okay. Which brings us to 16.1 and G12.
Thank you, Mr. Chair. Yes, I'd like to move this amendment that basically, instead of putting a prohibition with exceptions that are very large, put in a positive requirement that the minister look for alternative methods other than animal testing. I, like many others, find the testing of vertebrate animals should be minimized as much as possible and eventually eliminated as soon as we can. So I would like to propose that the minister, to the extent practical, use scientifically justified alternative methods and strategies to replace, reduce, or refine the use of vertebrate animals in the generation data and the conduct of investigations under paragraph 68A. So we know that our government is already working on a number of fronts to reduce the reliance on animal toxicity testing. So investing in research to support the development and use of alternative non-animal methods, developing a strategy on animal testing under SEEP. The government will engage with stakeholders to continue to move forward. And we know Health Canada is already working towards a ban on cosmetic testing on animals. So I think we're all in accord, but I just wanted to have a positive requirement that the government look at other ways of testing these substances rather than using animals. Thank you.
Merci. Et je tiens à vous dire.
Thank you. And I'd like to say that if we adopt this amendment, the one presented by Ms. Taylor-Roy, Amendment NDP 15 will not be able to be presented due to a lines conflict. Are there any other comments on G12? Mr. Longfield.
Just commenting because I know I've got constituents watching this section carefully. The Guelph Humane Society and the University of Guelph have been working on reducing testing and really getting to a better place than where we are right now. So I hope going forward with this legislation that engaging with stakeholders being part of it, that we'll get to a better place.
I have Ms. Posey and then Mr. McLean. I have a question. When we read the clause, in order to reduce, replace, or refine the use of vertebrate animals, this is something we also mentioned in an earlier clause. What does refine mean? Does it mean that if we can find a technique that we will be able to continue with vertebrate animals? That is a question for our officials from the department. Do one of the two experts online want to answer this question?
Vous êtes en sourdine. Vous êtes en sourdine. Oui.
Mr. Chair, we're joined by Mr. I have an echo.
I apologize. I did mention that at the beginning. Mr. Is it Caro? Yeah. Yes.
Yeah, Mr. Caro from Health Canada.
Okay, so Mr. Caro, est-ce que vous aimeriez
Mr. Caro, would you like to answer this?
As was outlined, the government is actively working to reduce reliance on animal testing with the ultimate goal of phasing out animal testing over time. But as it stands currently, alternatives are not sufficiently developed in order to replace all animal testing that's required to ensure the safety of Canadians from chemicals. So the term refine is intended to be included in the scope of efforts to reduce animal testing, such that when animal testing is absolutely essential to protect Canadians, it is done in a way that is humane as possible to the animals during the animal testing process.
Well, as I understand it, the idea of to refine means to modify the process or procedures in such a way as it's in the direction of being less harmful to animals. Right. Okay, Mr. McLean.
I'm fully in support of not using vertebrate animals for the testing that we need going forward. With the amendment, and the spirit of the amendment is very clear and very positive. What I'm wondering is between the words that are in the legislation right now and the words that we're proposing to change them with, as much as we're hoping for the gaps to be filled, is there a gap, and I'll ask this of the officials, Mr. Caro, please, is there a gap between the wordings being proposed in the amendment and the current state of where we are in Canada, where where things are going? There's obviously going to be where we have our eye on all the time. Where things are we going to have to fill the gap in the meantime? Is the question I have. Is there anything missing here? Is if you don't mind me saying, is the amendment a nicer way of saying exactly what's in the current legislation? If not, is there a gap between what's in the amendment and what's in the legislation?
Thank you for the question. There are certainly gaps in the sense that alternative methods to replace animal testing aren't fully developed and aren't fully validated in their ability to replace all animal testing currently. But the proposed amendments that we're talking about in G12 enable a strong, it's a message that alternative methods will be considered and used to the extent practicable, but recognizing that the animal testing will still be necessary to protect Canadians from human health. So I hope that's clear.
Mr. Couric and then Ms. Collins.
Thank you, Chair. Just a further question to clarify. I know that the Senate had added, had more or less added this this part to the bill, and just some of the concerns that we heard from testimony about how although very much agreed the need to limit, reduce, and ultimately eliminate animal testing. Just the what seems like a refining of the language here, and Ms. Taylor-Roy mentioned that she tried to put it in a positive, but certainly when I read through this, it looked like a refining of the language to ensure that it finds that right balance that is necessary, so that, as was mentioned, the health and safety of Canadians, where there are not other scientific methods. So I'm just wondering if the changes do in fact refine. Just to clarify, I know Mr. McLean had asked on this as well, but does this clarify and make more definitive exactly what the responsibility of both the government and then its impact on research and industry? Is there does this fit within what is required to actually be reasonable while attempting to accomplish what is certainly the intent at the reduction and eventual elimination of animal testing? To whoever is best fit to answer that.
Maybe I can answer that just on the way it's structured. I think the way that the amendment came to this committee, it was that no research and investigation should be done unless it's not reasonably possible to obtain. So it's like a test that you have to ask every single time, and it may even extend to past tests. And I think the idea was everybody has the same goal of eliminating vertebrate animal testing and reducing it in the meantime, and that's the duty on the government, is to keep moving in that direction. So it was but we don't want an administrative sort of checkpoint for every single action that the researchers are going to be doing. We want a general duty, a way of working that will move us towards elimination of vertebrate testing, but not a requirement to answer that question on an administrative requirement to answer that in every single case.
Thank you for that. Just curious, not just related to this amendment, but I guess this is probably a bigger question. You mentioned the administrative checkpoint, and just wondering if there is, if you could comment on reporting requirements that specifically related to this amendment, but maybe the bigger picture as well, when it comes to the impact that this would have on specifically, I'm thinking of research institutions, public and private entities that are doing testing currently, whether that be companies departments of universities. Just wondering about the administrative and reporting requirements associated with what's being proposed here.
I mean, in this particular section, there are no administrative requirements placed on others.
Okay.
Yeah, exactly. Exactly. This is an obligation on government. The ministers shall use, to the extent practicable, use. So there's no, this is not an obligation on industry. This is not an obligation on university labs, except to the extent that they are working directly for ministers or the department in conducting risk assessments. And there are no reporting obligations either, other than the overarching reporting obligation that the ministers have to provide an annual report of activities under the Act.
My understanding is that generally this does not fall. Animal testing does not generally fall under federal jurisdiction. I'm wondering if that's the reason why there's no obligation on entities, except when you're talking about cosmetics, we regulate through the Food and Drugs Act, I guess, or the Products Act. But anyway, can I go to Ms. Collins now? Yeah. No.
Thank you, Mr. Chair. And yeah, I think, definitely I appreciate hearing from the officials. I think what the testimony clarified for me was that the Senate amendment actually created a requirement for the minister. Or created a requirement for them to answer this question each time, that it was a kind of checkpoint. That seems beneficial in my mind, especially given that this government has committed to introduce legislation to end cosmetic testing by 2023, so this year, and also to phase out toxicity testing on animals by 2035. And I think if the government's serious about that, there should be some kind of requirement or checkpoint when it comes to addressing these issues.
Okay, is that that's a statement, not a question? It's okay. Yeah. Madame Posey?
Oui, je pense que je vais.
Yes, I would also like to make a comment. I think that this amendment casts aside all of 16.1 that was proposed by the Senate. Earlier, when I was asking my question about refine, it harkens back to NDP 14 that was speaking to this verb. If we accept this one, it doesn't help us find other ways of doing rather than focusing on vertebrate animals. We're just trying to refine what we do to these vertebrates. But in the Senate's comments, there were exceptions that were listed. They said at first, ministers cannot rely on methods, but then they list exceptions. So on one hand, it's either not reasonably possible to collect data or to investigate in other ways. It's much more restrictive. So there's the idea of refining in the Senate idea, but it's much more specific and says which cases would allow vertebrate animals to be used. And this is why I will vote against G12, because I find that 16.1 is fulsome. It says no, but here are some exceptions. The details are important because refine is very unspecific.
Roy?
Yes, thank you. And I just want to be clear that that certainly wasn't my intention. The original amendment that was put in, the exceptions did not require any kind of checklist. And the exceptions are very, very large. And in meeting and talking to many animal rights organizations and organizations that are doing research on non-animal testing, the intent here was to put the onus on the minister to ensure that they supported and looked at all these new techniques and ways that are being utilized to do research without using animals. So I met with numerous people who are doing amazing things, and there's just not the support of the use. Now, as was said, we don't control all animal testing, but certainly what the minister engages for research, I felt should be trying to look at all the non-animal testing options that are out there, even if they're not widely used yet or commercially available. So that was the intent, because I felt that the exceptions in here originally were so large that it was basically the same thing, except saying now, but we want the minister to go out and look for these other alternatives before they use animal testing. So that was the idea.
Collins?
Yeah, I'm curious if Ms. Taylor-Roy would be open to potentially a friendly amendment that would have this same language rather than replacing lines 3 to 21, have it as an addition. That way we would keep the checkpoints and the requirement to answer this question each time, but you also have the additional, what I hear her intention was really to add a requirement for the minister to have a broader view of these strategies and this movement towards reducing and replacing the use of animals. So
you're
keeping the
proposing
same
a
language.
sub-amendment.
Yeah, sub-amendment would be keep the same language, but don't delete the rest.
So I'm just going to if you could give me a moment here, I just want to. So what are you? Can you, Ms. Collins? Can you just explain again what you're proposing? We're talking about
right now
68.1, yeah.
The way that G12 reads is that it would replace a whole section. And what my proposal is that rather than replacing, it would be an addition to, so at the beginning of lines 3 to 21, you'd have this paragraph, and then you'd keep lines 3 to 21 as well.
Okay, do the legislative clerks, have they registered that? Vous comprenez ce qu'on veut faire?
You understand what we're trying to do? Okay, so we'll take a short break. It might be more complex than it appears.
But I'm open to either one. I think I hear the value in Ms. Taylor-Roy's proposal in adding a kind of additional requirement on the minister, but I think deleting the other requirements and the requirement specifically to answer this question each time and having checkpoints would do a disservice and water down the Senate amendment.
Can we just pause for a minute while the legislative clerks have a look at this? believe Mr. Duguid had a point of order or some
Yes, point of order, Mr. Chair. I had the opportunity to have a brief word with the legislative clerk, understand, and they helped me understand the complexity of the amendment that has been proposed. I know there's been some work done on that. For one, Mr. Speaker, I think members on this side of the House would like to see that amendment in writing, and we're almost to the close of our time, and it might be good to start fresh at the next meeting, so I would propose adjournment.
The idea is you would, Ms. Collins, you would submit it to us in writing, the amendment, and then we'll start the next meeting with a discussion of, well, it's a sub-amendment, basically. Everyone in agreement? We adjourn? Yeah, okay.